Donald Trump just announced that he is now not going to testify at his New York civil trial tomorrow. Just moments ago, in a long, rambling Truth Social sentiment, Trump said, quote, "I have already testified to everything and have nothing more to say other than that this is a complete and total election interference Biden campaign witch hunt that will do nothing but keep businesses out of New York. I will not be testifying on Monday." That from the former president. So for days, though, Trump had vowed that he would be retaking the witness stand tomorrow in the high-stakes trial that threatens his real estate business. New York Attorney General Letitia James is suing Trump for $250 million and seeking to bar him from doing business in the state.
All right, folks, you're locked in with Adam. Donald Trump consistently avoids testifying under oath, the one accountability setting no amount of money or lawyers can protect him from. His public bravado vanishes when words become binding, revealing a stark refusal to face cross-examination. Let us paint the picture clearly, because this is a story that demands to be understood in full color, not in black and white. Every single day, Donald Trump stands before crowds of thousands. He speaks into cameras that broadcast to millions. He types furiously into his phone at 3 a.m, sending messages to his followers that spread across the internet like wildfire. And in every single one of these settings, he tells the same story. He is innocent. He is persecuted. The cases against him are nothing more than witch hunts, orchestrated by political enemies who cannot accept his continued relevance. The judges are corrupt, the prosecutors are partisan, the evidence is manufactured, the investigations are rigged.
I just want to say before we begin, these are all Biden trials. This is done as election interference. Everybody knows it. I'm here instead of being able to be in Pennsylvania and Georgia and lots of other places campaigning, and it's very unfair.
Former President Trump is taking aim at President Biden today ahead of his hush money trial. Opening statements are now underway before entering court. The former president called the case a witch hunt. Connor Hansen has the latest.
History is being made in this Manhattan court today as lawyers begin their opening statements in the first ever criminal trial against a former U.S. president.
This is a witch hunt, and it's a shame, and it comes out of Washington.
Former President Donald Trump returning to a New York City courtroom on Monday as opening statements take place in his hush money trial. Trump is accused of falsifying business records to cover up a $130,000 payment to buy the silence of adult film star Stormy Daniels during the 2016 presidential campaign.
The entire legal apparatus that has spent years examining his conduct, his business dealings, his actions on one of the darkest days in American history is nothing more than an elaborate conspiracy designed to destroy him politically and personally. He says these things with absolute conviction. He says them loudly. He says them repeatedly. He says them to anyone who will listen and many who would prefer not to. The rallies are filled with thousands of people who cheer every accusation, every denial, every assertion of victimhood. His social media platform pulses with his words, reaching millions of devoted followers who hang on every syllable. Television interviews, press conferences, fundraising emails, campaign ads, late-night social media rants, all of them carry the same consistent message. The man has never, ever been short of words when it comes to asserting his innocence and attacking the people who dare to question it. He is endlessly vocal, endlessly defiant, endlessly certain that he has been wronged.
President Donald Trump says he has irrefutable proof that he is innocent in his latest indictment, and he plans to reveal it on Monday at a news conference.
2 people from Illinois are also charged in the case.
Natalie back now with more. Natalie.
Yeah, the Chicago-based publicist who once worked for R. Kelly and Kanye West is facing racketeering charges tied to Trump's case. According to the indictment, Trevion Cootie traveled to an election worker's home in Georgia in January 2021 to pressure that worker to report claims of fraud. She's charged with 3 counts. Lutheran pastor Stephen C. Lee faces those charges and 2 others for allegedly attempting to unlawfully influence a witness. Some of the charges used in this indictment were originally created to combat organized crime. Here's how they're relevant today.
Actions on their own may or may not violate a particular law, but actions taken together, especially when there's more than 2 people involved, constitute a conspiracy, racketeering, and undue influence. And so these are ways that prosecutors can get at some of the thornier crimes.
In his defense, former President Donald Trump says he has hard evidence that will exonerate him, and he's planning to present that evidence to the media on Monday at 10 a.m. our time in New Jersey.
And then the courts speak. And here is where the performance meets reality. The courts say something remarkably simple. They say, "We have heard your public statements. We have seen your social media posts. We have read your interviews and watched your press conferences. And we are genuinely curious. If everything you say is true, if you are truly innocent of all wrongdoing, if these investigations are really nothing more than politically motivated witch hunts, then come in and tell us. Raise your right hand. Swear to tell the truth. Answer our questions under penalty of perjury. Give us your version of events in a setting where it would actually count." And what happens next is not a one-time occurrence. It is not an isolated incident. It is not something that happened once and can be explained away as a legal strategy. It is a pattern so consistent, so documented, so repeated across so many proceedings in so many jurisdictions over so many years that it tells a story all by itself. A story about a man who will say anything in public, but will do almost anything to avoid saying it in a setting where lies carry consequences.
Why must you testify, Mr. Trump?
The defense in Donald Trump's criminal hush money trial rested its case on Tuesday, without calling the former U.S. president to testify.
Risky for you to testify.
I'm testifying. I tell the truth.
For weeks, Trump had stoked speculation about whether he would take the stand, telling reporters in April that he, quote, absolutely would.
You plan to testify in your trial in New York?
Yeah, I would testify, absolutely. It's a scam.
But Trump ultimately opted not to take the stand in his own defense. Criminal defendants typically do not testify in their own trials, as it exposes them to probing questions from prosecutors. Trump's legal team called 2 witnesses on his behalf, including lawyer Robert Costello. He testified that Trump's former fixer, Michael Cohen, the prosecution's star witness, told him he did not have any incriminating information on Trump. Cohen's testimony wrapped on Monday. The defense attempted to get the case dismissed, arguing that the trial rested on the testimony of a person with a well-documented history of lying. But the judge indicated that he was inclined to let jurors assess Cohen's credibility for themselves.
Think about what the law actually requires when you are called to testify under oath. It is not complicated. You appear. You raise your right hand. You promise to tell the truth. You answer the questions that are asked of you. You do not get to pick and choose which questions to answer. You do not get to filibuster or deflect or change the subject. You do not get to attack the questioner or claim persecution or invoke political victimhood. You answer. And if you refuse, there are consequences. If you lie, there are even more serious consequences. It is the most fundamental accountability mechanism in the American legal system. And across impeachments, civil fraud investigations, January 6th proceedings, criminal cases, civil lawsuits, and congressional inquiries, Donald Trump has shown us exactly what he thinks of that mechanism. He says no. He fights the subpoena. He appeals the order. He hides behind legal technicalities. He invokes the Fifth Amendment hundreds of times in a single deposition rather than answer questions about his business. He does almost anything, except the one thing that would actually provide the evidence for what he keeps saying publicly about his own innocence. He will not swear an oath and testify. The pattern is not subtle. It is not ambiguous. It is not something that can be dismissed as mere legal strategy or prudent counsel. It is screamingly obvious. It is documented in court records, in deposition transcripts, in judicial opinions, in committee reports. It has been observed by judges, legal experts, political commentators, and ordinary citizens alike. And it raises a question that cannot be avoided. Why would a man who claims innocence avoid the one setting where he could definitively prove it? Why would someone who insists he has done nothing wrong refuse to say so under oath? Why would a person who attacks his accusers at every opportunity choose silence when the law demands answers? The answer is uncomfortable but inescapable. He is not behaving like an innocent man. Innocent people, given the opportunity to clear their names under oath, take that opportunity. They welcome it. They say, "Bring on the questions, I have nothing to hide." Let me set the record straight. Donald Trump has never done that. Not once. Not in any proceeding. Not in any setting. And the record of his refusals is so extensive that it becomes evidence in itself. Let us start at the beginning of this pattern because the consistency is what makes it so compelling. The second impeachment of Donald Trump, which took place after the events of January 6, 2021, represents perhaps the clearest illustration of his relationship with sworn testimony. House impeachment manager Jamie Raskin did something unprecedented. He formally and publicly invited Donald Trump to testify under oath about the events of that day. He offered to question him before the Senate trial, giving Trump the specific opportunity to come in, raise his right hand, and tell his version of events on the record where it would actually count. This was not a trap. This was not an ambush. This was a genuine invitation for the accused to defend himself in the most straightforward way possible. Raskin was essentially saying, "You have told the American people that you are innocent. You have said that you did nothing wrong. You have claimed that you bear no responsibility for what happened. Now here is your chance. Come testify, tell the truth, set the record straight." Trump's lawyers refused. They called the impeachment unconstitutional. They called it a public relations stunt. They gave every reason, except the one that would have involved their client actually answering questions under oath. And Raskin, responding to that refusal, issued a statement that said exactly what any reasonable observer would conclude. He said Trump's immediate refusal to testify speaks volumes. He said it supports an inference of guilt, and he was absolutely right. Because when you have been invited to defend yourself under oath, and you refuse, you are telling the world something very specific. You are saying that you do not trust your own version of events. You are saying that you are afraid of what would happen if your words were subjected to cross-examination. You are saying that the public performance of innocence is not something you are willing to make legally binding, and that refusal carries meaning. This is not just about the impeachment. This is the beginning of a pattern that extends across years and across multiple types of legal proceedings. It is a pattern that has been observed and documented by judges, by legal experts, by journalists, and by anyone who pays attention. The man who cannot stop talking about his innocence in public refuses to say a single word about it under oath. The man who attacks his accusers constantly becomes silent when the consequences of speaking are real. The man who demands that everyone believe him refuses to provide the one form of evidence that would actually prove his claims. And that pattern, repeated over and over and over again, tells a story that cannot be ignored. The legal mechanics of what Donald Trump has been doing are worth understanding in detail, because this is where the pattern becomes not just politically interesting, but legally consequential. There is a tendency, when discussing Trump's legal troubles, to get lost in the noise. The indictments, the investigations, the subpoenas, the appeals, the daily headlines that blur together into an overwhelming torrent of information. But if you step back and look at the structure of what he is doing, a clear pattern emerges. And understanding that pattern requires understanding what the law actually says and what it does not say. Donald Trump, like every other American, has certain rights in legal proceedings. He has the right under the Fifth Amendment to decline to answer questions that might incriminate him in a criminal proceeding. That is a real and constitutionally protected right, and invoking it is not inherently evidence of guilt in a criminal trial context. Courts instruct juries not to draw adverse inferences from a criminal defendant's decision not to testify. That protection is important and exists for good reason. The founders understood that forcing someone to testify against themselves is fundamentally unfair, and they built protections against that into the Constitution. But here is what that right does not include, and this is the part that is critical to understanding what Trump's behavior actually means. It does not include the right to ignore a subpoena entirely. It does not include the right to refuse to appear at all. It does not include the right to refuse to answer every single question in a civil deposition, where courts and opposing parties are absolutely permitted to draw whatever reasonable inferences they choose from a blanket refusal to answer. And it absolutely does not include the right to lie. When Trump fights to avoid being deposed altogether, when he appeals court orders compelling his appearance, when he argues that he should not have to show up at all, he is not invoking the Fifth Amendment. He is claiming a different and much broader immunity from legal process that the courts repeatedly and consistently have rejected. The courts have ruled that he must answer questions or invoke the Fifth on a question-by-question basis with a specific reason for each invocation. He has no blanket right to simply stay away from sworn proceedings, the way a person who had nothing to hide might enthusiastically choose to do. This distinction is crucial because it exposes the fundamental dishonesty in Trump's approach. He is not exercising his constitutional rights. He is evading the legal process altogether. He is trying to make himself immune from questioning entirely, not just from answering specific questions that might incriminate him. And the courts have repeatedly told him that he cannot do that. Now, let us talk about what invoking the Fifth Amendment more than 400 times actually means in practice, because that specific number from the New York civil fraud deposition is worth examining carefully. When someone invokes the Fifth Amendment, they are saying specifically that answering this question might tend to incriminate them. That is the constitutional standard. It is not a general right to say nothing whenever you find the questions inconvenient or politically awkward. It is a specific right tied to specific potential criminal exposure. So when Trump invoked the Fifth more than 400 times in a civil fraud deposition, he was saying hundreds of times, question by question, that answering this question about his business practices, his financial statements, his asset valuations, his decisions about how to present his net worth to lenders, insurers, and tax authorities, answering this specific question might expose him to criminal prosecution. He was 400 times in the presence of lawyers and investigators, acknowledging that he had potential criminal exposure on each of those questions. That is not an assertion of innocence. That is not a confident claim that the investigation is a witch hunt. That is a sitting former president in a legal proceeding, indicating 400 separate times that he was unwilling to answer questions about his business practices because the answers might be used against him in a criminal case. And then, in public at his rallies, he kept telling audiences the whole thing was fake. The contradiction between what he said publicly and what he did legally is one of the clearest illustrations of the gap between his performance of innocence and his actual behavior when the accountability is real. At his rallies, he told his supporters that the investigation was a witch hunt, that the prosecutors were corrupt, that the entire case was a political hit job. Under oath, he said nothing. He sat in silence. He invoked his right against self-incrimination hundreds of times. The gap between the public performance and the private legal behavior is so wide that it cannot be dismissed. It demands an explanation, and the only credible explanation is that he was afraid to answer the questions honestly. The January 6th committee situation is particularly revealing about how Trump understands his exposure and his relationship to sworn testimony in the specific context that involves his most serious conduct. The committee subpoenaed him for documents and a deposition. Constitutional experts were clear. He had no legal basis for refusing to comply outside of invoking the Fifth on individual questions. His legal team spent months fighting it, delaying it, raising procedural objections, making arguments that courts and legal experts generally found unpersuasive. And ultimately, he never testified. He never sat down before that committee under oath and explained on the record what he knew about January 6th, what he was told, what he ordered, what he chose not to do. The committee ultimately closed without getting that testimony. And here is why that matters beyond the politics of the moment. The things Trump would have been asked about under oath are the very things that define his conduct on that day. What did he know about the planning before January 6th? What was he told as the events unfolded? Why did he wait hours to tell his supporters to stop? What was discussed in the White House during those hours? These are not questions with comfortable answers for someone who was watching events unfold and doing nothing. And the fact that he fought the subpoena every step of the way and never showed up tells you that his lawyers made the same assessment that any competent attorney would make. The honest answers to those questions were dangerous. The alternative, lying under oath, was an even bigger risk. So the answer was never to testify, never to raise the right hand, never to put the account on the record where it could be tested, cross-examined, and compared to the documentary and testimonial record that already existed. The hush money criminal trial provided yet another illustration of this consistent pattern. Judge Merchan had to sit down and explain to Trump from the bench, publicly and on the record, that his right was to testify or not testify, not to lie, not to dodge, not to use the gag order as an excuse to avoid the witness stand. The gag order only limited what he could say outside the courtroom. Inside the courtroom, under oath, he was free to testify. He chose not to. The judge had to publicly clarify that the gag order he had imposed, the same gag order that Trump had violated 10 separate times and that resulted in jail being threatened, did not prevent Trump from testifying. He told Trump from the bench, "You have an unequivocal right to testify in court. You also possess the absolute right to refrain from testifying. What you do not have is the right to misrepresent the gag order as the reason you cannot take the stand." The gag order limited what Trump could say about jurors and witnesses outside the courtroom. Inside the courtroom, under oath, he was free to testify in his own defense anytime he chose. He chose not to. And that choice, made after a judge had to explicitly clarify there was no legal barrier to testifying, is itself the story. There was no obstacle. There was no gag order excuse. There was just a defendant who chose, given the full opportunity, not to raise his right hand and tell his version of events under penalty of perjury in the middle of a trial where he kept insisting at every opportunity that he was innocent and being persecuted. He had the chance to say that under oath. He did not take it. Let us not overlook the 2019 Trump Tower protester case, because it shows this pattern predates his second term and even his first impeachment. A New York judge ordered then-President Trump to provide video testimony in a civil case over protesters allegedly assaulted by his security team outside Trump Tower. The judge called his account essential to the case and directed him to sit for a deposition before trial. This was a judge ordering a sitting president to swear an oath and answer questions even while in office, undercutting every argument that presidential status places him above the ordinary legal obligations that every other American faces in civil proceedings. The courts have consistently, across years and across many different types of cases, applied the same rule. You must appear. You must answer or invoke the fifth on specific questions with a specific legal basis. You do not get to simply disappear from legal proceedings because you are powerful or politically connected, or because you find the questions inconvenient. The pattern is now so extensive, so documented, and so consistent across so many different types of proceedings that it tells a very complete and very specific story about how Trump relates to the one accountability mechanism that is genuinely difficult to manage from the outside: sworn testimony under penalty of perjury. This is the setting where the performance stops, where the rally talking points run out, where the true social posts do not protect you, where the only thing that matters is what you say with your right hand raised in front of a court official, with a transcript running and cross-examination waiting. And across every opportunity he has had to enter that setting, Trump has found a way not to. Here is the documented record across multiple proceedings in multiple years. The second impeachment offered the opportunity to testify under oath about January 6th by the lead impeachment manager himself. Refused immediately, with the impeachment manager saying publicly that the immediate refusal speaks volumes and supports an inference of guilt. The New York civil fraud case ordered by a judge and upheld on appeal by an appellate court to sit for a deposition. Appeared and invoked the Fifth Amendment more than 400 times, rather than answer questions about his business practices and financial statements. The January 6th committee subpoenaed for documents and a deposition under oath by a bipartisan congressional committee. Fought it procedurally for months with arguments that constitutional experts said lacked legal merit. Never testified. The hush money criminal trial claimed the gag order prevented him from testifying. Corrected publicly by the presiding judge, who confirmed on the record that there was no such barrier. Still chose not to take the stand in his own defense. The Trump Tower protester case in 2019, ordered by a New York judge to provide video testimony while he was sitting president, with the judge calling his account essential to the proceedings, demonstrating that courts can compel him to appear even while in office. That is the record. That is the documented history. 5 separate proceedings, 5 separate opportunities to raise the right hand and tell the truth under oath. And across all 5, the oath was never freely and fully taken. Now, here is why the refusal matters beyond just political optics. This is important to understand clearly and specifically because the legal consequences are real and documented. When someone refuses to testify under oath in a civil proceeding, not a criminal trial where the Fifth Amendment protects against adverse inference, but a civil case or a civil investigation, courts and opposing parties are specifically permitted to draw what are called adverse inferences from that refusal. They can conclude and can legally state in their findings that the refusal to answer specific questions suggests the answers would have been harmful to the person refusing. That is not speculation. That is a documented and established legal consequence of invoking the Fifth Amendment in a civil context, a context that is fundamentally different from a criminal trial. When Trump invoked the Fifth more than 400 times in the New York civil fraud deposition, Judge Engoron was legally permitted to draw adverse inferences from those refusals. He concluded that the unwillingness to answer questions about specific financial practices was itself evidence that the honest answers would have been damaging and inconsistent with the public claims Trump had been making about his financial standing and the value of his assets. In his ultimate finding that Trump and his company had massively and systematically overstated asset values in financial statements over many years, the judge was supported in part by those adverse inferences drawn from the 400-plus refusals to answer. The refusal to testify honestly was not just a political embarrassment or a legal strategy that preserved his options. It was legally consequential in the most direct possible way. it contributed to the findings of fraud that produced initial penalties exceeding $350 million. The strategy of refusing to answer rather than telling the truth did not protect Trump from accountability. It became part of the evidentiary basis for the accountability itself. The constitutional picture is also worth making fully explicit because Trump's legal teams have repeatedly and creatively tried to argue that some form of presidential immunity, executive privilege, or constitutional protection exempts him from the normal legal obligations that every other American faces when they are subpoenaed or ordered to testify in civil or congressional proceedings. Courts have consistently, across years and across multiple different types of cases, rejected those arguments. The appeals court that upheld the deposition order in the New York civil fraud case specifically and indirectly rejected Trump's argument that the investigation violated his constitutional rights simply because a parallel criminal investigation existed in the same subject matter area. The constitutional law experts who analyzed the January 6th subpoena specifically and unambiguously concluded that he had no legal basis for refusing to comply beyond invoking the Fifth Amendment on individual questions with specific justifications. For each invocation, Judge Merchan in open court specifically corrected his publicly stated claim that the gag order prevented him from testifying, a claim that was flatly and demonstrably false given the explicit and narrow scope of the order. At every turn, across every type of legal proceeding, in every type of legal argument, courts have applied the same foundational principle. No one is above the law. No one gets to stand in the way of legitimate legal process simply because they hold or have held political power. That is what Letitia James said when Engoron's deposition order was upheld. And that is what every court that has ruled on these questions has effectively reaffirmed. The law applies to Donald Trump the same way it applies to everyone else. And the law says you must appear, you must answer or invoke specific rights with specific legal justifications. And you do not get to disappear from proceedings simply because you find the questions inconvenient or dangerous to answer honestly. Trump will say anything publicly to assert innocence. But when courts ask him to testify under oath, he fights every subpoena, invokes the Fifth hundreds of times, and avoids the witness stand at all costs. Innocent people don't avoid the oath, and his documented pattern of evasion speaks louder than any rally denial.